A black teenager stands before Judge Harrison, who sneers at her torn jeans and dismisses her as another troubled youth. But when she opens her briefcase and reveals her bar certification, the courtroom falls silent. What happens next will change everything this judge believes about justice. Before we continue, don't forget to subscribe to the channel, like the video, and comment on where you're watching from. Let's get started. They say justice is blind, but in Judge Richard Montgomery's courtroom, it had become something far worse: prejudiced, calculated, and cruel. For nearly 2 decades, Judge Montgomery had ruled courtroom 15B like his personal kingdom, where his word was law and his biases went unchallenged. The judicial black robe that once symbolized impartiality had become his armor, deflecting criticism and accountability, while he dispensed what he called justice, but what many whispered was merely the enforcement of his own narrow worldview. On this unseasonably warm Monday morning, Montgomery adjusted his reading glasses, looking down from his bench at the young black woman standing before him. She couldn't have been more than 19, dressed in a simple navy blue blazer over a white blouse, her natural hair styled in neat professional twists. Her posture was perfect, shoulders squared, chin lifted slightly, but Montgomery didn't see the dignity in her stance. He saw only what he expected to see: another delinquent wasting his court's valuable time. "Ms. Taylor," he drawled, not bothering to hide the condescension in his voice. "I see you've decided to represent yourself today. Bold choice for someone so—" He paused, eyes flicking dismissively over her. "Inexperienced." The gallery behind her stirred uncomfortably. Assistant District Attorney Parker winced slightly, though he quickly masked his reaction. He'd worked with Montgomery long enough to recognize the judge's tone. This wasn't going to be pretty. "Yes, Your Honor," Zoe Taylor replied, her voice steady and clear. "I am exercising my constitutional right to represent myself in these proceedings." Montgomery's eyebrows rose fractionally. The girl spoke well, he'd give her that. Too bad articulation wouldn't save her from the charge of criminal trespass and disturbing the peace, charges that stemmed from her participation in a protest at the Sterling corporate headquarters 3 weeks prior. "Very well," Montgomery sighed dramatically, as if her decision had personally inconvenienced him. "Though I must advise you that representing oneself often leads to unfortunate outcomes. As the saying goes, even attorneys who represent themselves have a fool for a client." He smiled thinly at his own joke. Several of the court officers chuckled dutifully. They knew which side their bread was buttered on. "I'm familiar with the adage, Your Honor," Zoe replied, unruffled. "I believe it was Justice Scalia who added the observation that a criminal defendant who represents himself has an idiot for a client. However, I'm confident in my decision." Montgomery's smile faltered. Few defendants in his courtroom quoted Supreme Court justices, especially not 19-year-olds from the east side of the city. He glanced down at the file before him, scanning it more carefully this time. "Let's proceed then," he said curtly. "Ms. Taylor, you are charged with criminal trespass in the 2nd degree and disturbing the peace. How do you plead?" "Not guilty, Your Honor," Zoe stated firmly. "Of course," Montgomery muttered, just loudly enough to be heard. "Ada Parker, your opening statement." Parker rose, straightening his tie. "Thank you, Your Honor. The state will prove that on April 15th, the defendant, Zoe Taylor, knowingly and unlawfully entered the private property of Sterling Corporation, despite clear signage prohibiting such entry. Once there, she disrupted business operations by leading chants through a megaphone, refusing to leave when asked by security personnel, and had to be physically removed from the premises by police officers. Her actions were deliberate, disruptive, and clearly illegal. The state seeks the maximum penalty for these offenses." Montgomery nodded approvingly. "Thank you, Mr. Parker. Ms. Taylor, your opening statement, if you have one." The condescension in his tone was unmistakable. He expected her to fumble through some half-formed argument about free speech or racism, the usual defenses he'd heard and dismissed countless times before. Zoe stood, gathering her notes with calm precision. "Thank you, Your Honor. The defense will demonstrate that I did not knowingly and unlawfully enter private property, as the protest was conducted in an area that Sterling Corporation has historically maintained as a public forum. Furthermore, I will establish that my actions fall well within the boundaries of protected speech under the First Amendment, and that the manner of my removal from the premises constituted excessive force in response to peaceful protest. Finally, I will show that these charges represent a pattern of selective prosecution against civil rights demonstrators, while similar actions by other groups go uncharged." For a brief moment, Montgomery's practiced judicial mask slipped, revealing genuine surprise. This wasn't the rambling statement he'd expected. He quickly recovered, leaning forward with narrowed eyes. "Ms. Taylor, this is a court of law, not a political science classroom. Save the constitutional lectures for your professor." "I'm simply outlining my defense, Your Honor, as is my right," Zoe replied evenly. "Proceed with your case, Mr. Parker," Montgomery said, ignoring her response. "And let's try to keep things moving. I have a full docket today." As the prosecution presented its case, calling first the Sterling security guard who had confronted Zoe and then the arresting officer, Montgomery made little effort to hide his bias. He sustained nearly every objection Parker raised, while overruling most of Zoe's, even those that were clearly valid under the rules of evidence. When Zoe attempted to cross-examine the security guard about Sterling's history of allowing other groups to gather in the same space, Montgomery cut her off. "Irrelevant, Ms. Taylor. Stick to the events of April 15th. "Your Honor," Zoe said calmly, "I'm establishing that the area in question has been maintained as a public forum, which is directly relevant to whether I knowingly trespassed on private property." "The property belongs to Sterling Corporation," Montgomery replied dismissively. "What they may or may not have allowed in the past is immaterial. With respect, Your Honor, that's not consistent with established First Amendment jurisprudence. In Marsh v. Alabama and subsequent cases, the Supreme Court has recognized that—" "Ms. Taylor," Montgomery interrupted, his voice rising, "I don't need a first-year law student to explain jurisprudence to me. I've been on this bench for 19 years. A murmur ran through the courtroom. The judge's outburst was unusual, even for Montgomery, who was known for his sharp tongue. Something about this young defendant was getting under his skin. "My apologies, Your Honor," Zoe said, the perfect picture of deference, though those watching closely might have noticed the slight tightening around her eyes. "May I continue my cross-examination?" Montgomery waved a hand impatiently. "Proceed, but keep it relevant." As the morning wore on, a strange tension built in the courtroom. Despite Montgomery's clear hostility, Zoe conducted herself with unexpected skill. Her questions were precise and strategic. She successfully impeached the officer's testimony by highlighting contradictions between his statements and his written report. She even managed to get the security guard to admit that other groups had held gatherings in the same area without being asked to leave. During a brief recess, Court Clerk Maria Vasquez approached Montgomery's chambers with additional files he had requested. She found the judge pacing, his face flushed with irritation. "Something isn't right," he muttered, almost to himself. "That girl, she's too polished, too prepared." He turned to Maria. "Did you run a background check like I asked?" Maria nodded, handing him a thin file. "Yes, Your Honor. Zoe Taylor, 19 years old. Graduated from Eastside High School last year. No prior arrests or citations. Currently works part-time at the Community Legal Aid Center as a receptionist." Montgomery frowned, flipping through the sparse documents. "That's it? No college?" "Not currently enrolled, sir." Montgomery closed the file, his brow furrowed. She quotes Supreme Court cases like a law professor. Where does a teenager from East Side learn to cross-examine witnesses like that? Maria hesitated, then ventured, perhaps from working at the Legal Aid Center? Perhaps, Montgomery echoed, unconvinced. Or perhaps Ms. Taylor isn't being entirely forthcoming about who she is. When court resumed, Montgomery watched Zoe more carefully. There was something in her mannerisms, the way she organized her notes, the precise language she used. It reminded him of someone, though he couldn't quite place who. As Zoe began her defense, calling her first witness, another protester who had been present but not arrested, Montgomery's suspicion deepened. Her direct examination was textbook perfect, establishing the peaceful nature of the protest and the selective enforcement of trespassing rules. "Your Honor," she said after dismissing her witness, "the defense would like to enter into evidence Exhibits A through D, photographs demonstrating various gatherings permitted on Sterling Corporation property over the past year." Montgomery frowned. "Approach the bench, Ms. Taylor." She did so with confidence, photographs in hand. "Where did you get these?" he demanded quietly. "Public records, Your Honor. Sterling Corporation's own social media accounts celebrating community events held on their plaza. The same plaza where I was arrested for trespassing." Montgomery studied the photographs, his frown deepening. She was right. They clearly showed various groups gathered in the same space, including a corporate-sponsored rally for a local sports team that had blocked the same entrance she was accused of obstructing. "I'll allow them," he said reluctantly, "but their relevance is limited." "Thank you, Your Honor," Zoe replied with perfect composure, returning to her table. As the afternoon progressed, Montgomery found himself increasingly unsettled. Despite his best efforts to hamper her defense, Zoe Taylor was systematically dismantling the prosecution's case with the skill of a seasoned attorney. Yet according to her file, she was just a teenager with a high school diploma and a part-time job answering phones. Who was Zoe Taylor really? And why did he have the unsettling feeling that he was being played? By late afternoon, as shadows lengthened across courtroom 15B, Judge Montgomery's irritation had transformed into something deeper, a gnawing suspicion that continued to distract him as the trial proceeded. The gallery had filled as word spread through the courthouse about the young woman who was holding her own against one of the city's most notoriously difficult judges. "The defense rests, Your Honor," Zoe announced, after methodically presenting evidence that contradicted nearly every element of the prosecution's case. Montgomery glanced at the clock. "We'll hear closing arguments then." He turned to ADA Parker, whose confident demeanor from the morning had noticeably diminished. "Mr. Parker?" Parker rose, gathering his notes with less assurance than he'd shown earlier. "Your Honor, despite Ms. Taylor's admittedly thorough defense, the facts remain clear. She entered private property after being informed it was private. She disrupted business operations. She refused to leave when asked. These actions constitute criminal trespass and disturbing the peace, regardless of what political message she was attempting to convey." He continued for several minutes, but his arguments sounded increasingly hollow in the face of the evidence Zoe had presented. When he finished, Montgomery nodded. "Thank you, Mr. Parker. Ms. Taylor?" Zoe stood, leaving her notes on the table, a move that didn't escape Montgomery's notice. Few experienced attorneys would deliver a closing argument without reference points, let alone a teenager representing herself. "Your Honor, the prosecution has failed to establish the essential elements of criminal trespass. As the evidence has shown, Sterling Corporation has consistently maintained their plaza as a public forum, hosting community events, permitting gatherings, and explicitly inviting public participation in that space. Under the legal standard established in Marsh v. Alabama and reinforced in Pruneyard Shopping Center v. Robbins, once private property is open to public use in this manner, the owners cannot selectively exclude individuals based on the content of their speech. She moved from behind the table, standing centered before the bench, her posture relaxed yet authoritative. Furthermore, the selective enforcement of trespassing regulations against protesters exercising their First Amendment rights, while permitting other gatherings in the same space, constitutes viewpoint discrimination prohibited under RAV v. City of St. Paul. The prosecution has presented no evidence that my actions disrupted business operations beyond what was permitted during the corporate-sponsored rally held in the same location just 1 week prior. Montgomery's eyes narrowed. Her argument wasn't just good, it was sophisticated, citing precedents that many practicing attorneys would overlook. Each time she referenced a Supreme Court case, she did so with precise relevance to the facts at hand, not as mere window dressing. The Constitution does not permit a double standard where corporate-approved speech is protected while dissenting voices are criminalized, Zoe continued. If the court finds me guilty today, it will not be because I violated the law, but because the law was selectively applied based on the content of my message. Such a decision would not only be unjust, but unconstitutional. She returned to her table, meeting Montgomery's gaze directly. The defense rests, Your Honor. A heavy silence fell over the courtroom. Even Parker looked impressed despite himself. Montgomery cleared his throat, trying to regain his composure and authority. Thank you, Miss Taylor. The court will take a 30-minute recess before delivering a verdict. As he rose, Montgomery caught sight of a woman in the back row of the gallery, middle-aged, elegantly dressed, with silver-streaked hair and a proud smile directed at Zoe. Something about her seemed familiar, though he couldn't place her. Before he could consider it further, he retreated to his chambers, unsettled and irritated. Once alone, Montgomery paced the confines of his office, unable to shake the feeling that he was missing something obvious. He pulled up Zoe's file again on his computer, searching for any detail he might have overlooked. Nothing. Just a teenager from the East Side with no prior record. He expanded his search, looking for any mentions of Zoe Taylor in local news. Perhaps she'd been involved in other protests, other legal matters. A knock at his door interrupted his search. "Enter," he called impatiently. Maria Vasquez stepped in. "Your Honor, I thought you might want to see this." She placed a folded newspaper on his desk, the alumni newsletter from State University Law School. "What is this, Maria?" he asked, confused. "Page 4, sir." Montgomery flipped to the indicated page and froze. There, smiling from a photograph, was the woman he'd noticed in the back of his courtroom, Professor Eleanora Wright, accepting an award for 25 years of distinguished teaching at the law school. The same Professor Wright who had famously won 17 consecutive cases before the state Supreme Court, most of them civil rights matters. The same Professor Wright who had, 15 years ago, handed Montgomery the most humiliating defeat of his career as a practicing attorney, before he'd secured his position on the bench. The article praised Wright's innovative approach to clinical education and mentioned her recent focus on preparing the next generation of civil rights attorneys. Montgomery's blood ran cold as pieces began falling into place. He returned to his computer, fingers flying across the keyboard as he searched for connections between Professor Wright and Zoe Taylor. What he found confirmed his suspicions. A small mention in a community newspaper about East Side Legal Clinic's youth mentorship program, featuring a photograph of Wright standing beside several teenagers, Zoe Taylor among them, identified as the program's most promising participant. Montgomery slammed his laptop closed. He'd been set up. This entire case, this charade of a self-represented teenager, was Professor Wright's doing. She'd coached the girl, prepared her, probably written every word of her arguments. And for what? To make him look foolish? To set up grounds for appeal? To lay a trap for him to reveal his biases on the record? When he returned to the courtroom, Montgomery's face was a mask of judicial calm, betrayed only by the tightness around his eyes and the rigid set of his shoulders. He took his seat, gavel in hand, surveying the room with newfound awareness. Zoe Taylor sat quietly at the defense table, the picture of respectful patience. In the gallery behind her, Professor Wright remained, now joined by several other individuals Montgomery recognized as civil rights attorneys and community activists. The pieces of the puzzle became even clearer. He was being watched, evaluated, perhaps even recorded beyond the official court transcript. "Before I deliver my verdict," Montgomery began, his voice carefully controlled, "I'd like to address something that has come to my attention." A ripple of tension moved through the courtroom. "Ms. Taylor," he continued, fixing her with a hard stare, "it appears you haven't been entirely forthcoming about your legal background." For the first time that day, Zoe looked genuinely surprised. "I'm not sure what you mean, Your Honor." "I think you do," Montgomery replied coldly. "Your connection to Professor Eleanora Wright and the East Side Legal Clinic's mentorship program suggests you've received significant legal coaching for these proceedings. While not technically improper, it does call into question the authenticity of your self-representation." Whispers erupted in the gallery. Montgomery noticed Professor Wright's expression shift from surprise to calculated observation. Zoe remained composed. "Your Honor, I have been fortunate to receive mentorship through community programs, including guidance from Professor Wright. However, every argument presented today, every question asked, and every objection raised came from my own understanding of the law. I prepared my own defense, as is my right. And you just happen to be familiar with obscure Supreme Court precedents?" Montgomery asked sarcastically. "With respect, Your Honor, Marsh vs. Alabama and RAV versus City of St. Paul aren't obscure. They're foundational First Amendment cases taught in basic civics education. The fact that you find it surprising that a young black woman would be familiar with her constitutional rights is—" She paused, choosing her words carefully. "Noteworthy." The courtroom fell silent. Montgomery realized, too late, that he'd walked directly into a trap of his own making. Any further questioning of her abilities would only reinforce the impression of bias. If he ruled against her now, after publicly questioning her capabilities because of her age and background, he would be handing her grounds for appeal on a silver platter. He was cornered, by a teenager. Or perhaps by Professor Wright, using this girl as her proxy. "The court is ready to render its verdict," Montgomery stated, his voice tight with suppressed anger. "On the charge of criminal trespass in the second degree, this court finds the defendant, Zoe Taylor." He paused, seeing the eager anticipation in the gallery, the calm readiness in Zoe's posture, the watchful eyes of Professor Wright. Whatever verdict he delivered now would reveal more about him than about the case before him. "Not guilty." Zoe's expression remained neutral, though the barest hint of satisfaction flickered in her eyes. "On the charge of disturbing the peace," Montgomery continued, "this court finds the defendant not guilty. Case dismissed." He brought the gavel down with more force than necessary, already rising to retreat to his chambers. "Court is adjourned." Montgomery slammed his chamber door with enough force to rattle the framed law degree on the wall. He yanked off his judicial robe and flung it across his leather chair, loosening his tie with agitated movements. The humiliation burned through him like acid, eating away at the carefully constructed facade of judicial temperament he'd maintained in the courtroom. "Maria!" he bellowed. His clerk appeared in the doorway, her expression carefully neutral. "Yes, Your Honor?" "Get me everything on Zoe Taylor. Everything. School records, employment history, social media. I want to know who this girl really is." Maria hesitated. "Sir, that might be overstepping the—" "Did I ask for your legal opinion?" Montgomery snapped. "Just do it." After she left, Montgomery sank into his chair, opening his laptop to continue his own investigation. Within minutes, he'd found several news articles about the Sterling protest. One photo showed Zoe among the protesters, megaphone in hand. But what caught his attention was another familiar face in the crowd. A tall black man with distinguished gray temples and wire-rimmed glasses. Professor James Bennett, constitutional law scholar and frequent commentator on judicial reform. First Wright, now Bennett. This wasn't coincidence. A soft knock interrupted his search. Ada Parker stood in the doorway, his expression troubled. "What is it, Parker?" Montgomery asked irritably. "I wanted to apologize for how that case went, Your Honor. I should have been better prepared." Montgomery waved dismissively. "We both got sandbagged. That girl wasn't just some random protester. She's connected to Eleanor Wright." Parker's eyebrows rose. "The civil rights attorney? The one who—" "Yes." Montgomery cut him off, not wanting to hear about his past defeat. "The very same. And it appears Professor Bennett was involved too. They set this whole thing up." Parker shifted uncomfortably. "With all due respect, sir, I'm not sure that changes the merits of the case. The evidence she presented about Sterling's inconsistent trespassing enforcement was pretty solid." Montgomery fixed him with an icy stare. "Whose side are you on, Parker?" "The law's side, sir, always." There was an unexpected firmness in the ADA's voice. "If you'll excuse me, I have another case to prepare." He left before Montgomery could respond. Montgomery turned back to his computer, expanding his search to include both professors alongside Zoe's name. What he found made his stomach clench. A small announcement in the law school's newsletter about a new initiative called The Justice Project, co-directed by Professors Wright and Bennett, described as an innovative program training promising young paralegals from underserved communities. And there, listed among the inaugural class of 12 participants, Zoe Taylor. She wasn't just some teenager working as a receptionist. She was a trained paralegal being mentored by two of the most progressive legal minds in the state, both of whom had very public disagreements with Montgomery's judicial philosophy over the years. His phone rang, the caller ID showing Judge Carlton, the chief administrative judge for the district. "Richard," Carlton's voice came through without preamble. "I just heard about the Taylor case." Montgomery straightened. "News travels fast." "It does when Professor Wright is involved. She's calling a press conference at 5. "A press conference? About a simple trespassing case?" Montgomery felt his blood pressure rising. "I suspect it's about more than that one case," Carlton replied carefully. "Richard, there's something you should know. The State Judicial Conduct Commission has received a series of complaints about your courtroom." Montgomery froze. "What complaints?" "Allegations of racial bias in rulings, inconsistent application of sentencing guidelines, inappropriate comments from the bench. They've apparently been gathering data for months." "This is absurd," Montgomery sputtered. "Who's behind this?" Carlton's sigh was audible. "It's anonymous, but the statistical analysis bears Professor Bennett's hallmarks. He's been publishing research on judicial bias patterns for years." Montgomery's mind raced. Bennett had been at the Sterling protest. Wright had been in his courtroom today. The Taylor girl, trained by both of them, had deliberately gotten herself arrested, then represented herself in his court, baiting him the entire time. "They're targeting me," he said flatly. "Richard, I've reviewed some of the preliminary data myself. The disparities in your sentencing and bond decisions are difficult to explain." Carlton's tone was gentler now, almost sympathetic. "The commission has voted to open a formal investigation." After the call ended, Montgomery sat motionless, the implications washing over him like ice water. His phone buzzed with a news alert. "Local teen defeats controversial judge, spotlight on judicial bias." The article was already online, complete with a photograph of Zoe Taylor standing on the courthouse steps, Professor Wright at her side, both smiling. The caption identified Zoe as a paralegal with the Justice Project, a program training legal advocates from disadvantaged communities. A quote from Wright praised Zoe's exceptional legal acumen and courage in confronting institutional bias, before noting that the case highlights ongoing concerns about Judge Montgomery's impartiality that will be addressed in today's press conference. Montgomery slammed his laptop closed. They had orchestrated the entire thing, the protest, the arrest, the trial, all to create a public spectacle that would trigger the investigation. And he had played right into their hands, revealing his biases on the record, just as they'd hoped. At 4:45, unable to resist, Montgomery slipped into the back of the press room where Wright's conference was scheduled. Reporters filled the seats, cameras set up along the sides. At precisely 5 o'clock, Professor Wright approached the podium. Flanked by Bennett and several others, Montgomery recognized as civil rights attorneys. Zoe stood slightly apart, now dressed in a formal pantsuit that gave her an even more professional appearance. "Thank you all for coming," Wright began, her resonant voice carrying without effort. "Today, the Justice Project is releasing a comprehensive report analyzing 5 years of court records from District Court Division B, presided over by Judge Richard Montgomery." An assistant distributed bound reports to the front row of journalists. "Our analysis reveals disturbing patterns of disparity in Judge Montgomery's courtroom," Wright continued. "Black defendants are 3.4 times more likely to be denied bail than white defendants with identical charges and backgrounds. Sentencing disparities average 40% longer incarceration for minorities compared to white defendants for equivalent offenses." She gestured to Professor Bennett, who stepped forward with additional statistical details, his academic tone lending authority to the damning figures. Montgomery felt physically ill as the presentation continued. They had dissected every ruling, every comment, every decision he'd made for years. The data was presented in cold, methodical terms, bar graphs, pie charts, trend lines, all pointing to patterns he had never consciously acknowledged. "But statistics only tell part of the story," Wright said, stepping aside. "Ms. Taylor will now share her experience from today's proceedings." Zoe approached the microphone with the same composure she'd shown in court. "My case today was fairly straightforward. A protest at a corporate headquarters resulting in trespassing charges. But from the moment I entered Judge Montgomery's courtroom, I experienced the same dismissive treatment and procedural obstacles our data shows are routinely directed at minority defendants." She detailed Montgomery's condescending remarks, his inconsistent evidentiary rulings, his visible surprise at her legal knowledge, presenting each as an example of the implicit bias documented in the report. "I represented myself not because I couldn't afford an attorney," she explained, "but because our project needed direct, contemporaneous documentation of judicial conduct that might not be reflected in official transcripts, facial expressions, tone of voice, selective attention to arguments." A reporter raised his hand. "Ms. Taylor, are you actually a 19-year-old receptionist, as was stated in court?" Zoe smiled slightly. "I'm 24, with a bachelor's degree in legal studies. I've been working as a paralegal with the Justice Project for the past 2 years while preparing for law school." "And did you deliberately get yourself arrested to set up this case?" another journalist asked. "The Sterling protest was genuine, organized by community activists concerned about environmental racism. I participated because I believe in the cause. The fact that it resulted in selective enforcement of trespassing laws against primarily minority protesters was predictable based on past patterns, but not engineered." From his position at the back of the room, Montgomery watched as his reputation unraveled thread by thread. No outlandish accusations, no personal attacks, just methodical presentation of evidence that was damning precisely because of its restraint and precision. As the conference concluded, Montgomery slipped out, unnoticed by the crowd. In the empty hallway, he leaned against the wall, feeling the weight of decades of unexamined decisions pressing down on him. For the first time in his judicial career, Richard Montgomery faced a reckoning he could not control, before a court of public opinion where his authority meant nothing. And it had all begun with a young woman he had underestimated from the moment she walked into his courtroom. The following morning, Judge Montgomery's name dominated every local news outlet. The headlines ranged from measured, "Study alleges bias in Montgomery courtroom," to damning, "Data reveals racial disparities in judges' rulings." The morning shows featured legal analysts dissecting the Justice Project's report, with several calling for Montgomery's immediate recusal from pending cases involving minority defendants. Montgomery had barely slept, alternating between rage and disbelief as he scrolled through the coverage on his tablet. By dawn, he'd convinced himself that this was nothing more than a coordinated attack by academic activists with a political agenda. By the time he arrived at the courthouse, slipping in through a side entrance to avoid the reporters gathered at the main steps, he had prepared a statement asserting his judicial integrity and dismissing the allegations as baseless statistical manipulation. But Judge Carlton was waiting in his chambers, along with a stern-faced woman Montgomery recognized as Sandra Diaz, general counsel for the court system. "Richard," Carlton began without preamble, "we need to discuss your docket for the immediate future." "If you're suggesting I recuse myself because of this witch hunt," Montgomery started. "This isn't a suggestion," Carlton interrupted. "The Chief Judge has temporarily reassigned your cases pending review by the Judicial Conduct Commission." Montgomery stared at him in disbelief. "You can't be serious. On what grounds?" Diaz stepped forward, her expression professionally neutral. "The Commission has received sufficient evidence to warrant investigation under Judicial Code Sections 2.2 and 2.3 regarding impartiality and bias. During this process, continuing to hear cases could create the appearance of impropriety and potentially compromise the integrity of verdicts." "This is unprecedented," Montgomery sputtered. "You're suspending me based on some biased research project?" "Not suspending," Carlton corrected carefully. "Temporarily reassigning your docket. You'll retain your title and salary while the investigation proceeds. You're also entitled to legal representation, which the court will provide if you wish." "This is Wright's doing," Montgomery said bitterly. "She's had it in for me since that affirmative action case 15 years ago." Carlton and Diaz exchanged glances. "Richard," Carlton said quietly, "I've reviewed the raw data myself. The patterns are consistent across hundreds of cases. This goes beyond any personal vendetta." After they left, Montgomery sat at his desk, the weight of the situation finally sinking in. His phone had been buzzing constantly. Colleagues, reporters, even an old law school friend who now taught judicial ethics at the state university. He ignored them all, staring instead at the framed photographs on his credenza. 30 years in the legal profession, nearly 2 decades on the bench. A career built on what he'd always believed was a commitment to law and order. Had it really just been prejudice in a black robe? By midday, he couldn't stand the confines of his chambers any longer. Avoiding the main corridors, he made his way to the small courthouse garden, a quiet spot few people used, tucked behind the administrative offices. To his surprise, someone was already there, seated on a bench beneath the single oak tree. Zoe Taylor looked up from her notebook as he approached, her expression betraying no surprise, as if she'd been expecting him. "Judge Montgomery," she acknowledged with a slight nod. He should have turned and walked away. Speaking to her could only complicate the investigation. But something, curiosity, anger, or perhaps a need to understand, made him stop. "Ms. Taylor," he replied stiffly. "Or should I say, paralegal Taylor, since you weren't exactly forthcoming about your identity." "I never lied in your courtroom," she replied calmly. "I am 19, I did graduate from Eastside High, and I do work part-time at the Community Legal Aid Center." I simply omitted my education and training since then. A lie of omission is still a lie. Is that what you tell yourself about your rulings, Judge Montgomery? The question was delivered without heat, almost gently, which somehow made it cut deeper. Montgomery felt his face flush. You don't know anything about my rulings beyond what your professors cherry-picked for their political agenda. I know about State versus Williams, she replied, closing her notebook. Marcus Williams, age 17, charged with possession with intent to distribute. First offense, honor roll student, caught with less than an ounce of marijuana. You denied him youthful offender status and sentenced him to 3 years. The same day, you granted youthful offender status to Bradley Thompson, age 17, similar charge, similar amount of drugs, but with a prior juvenile record. Marcus was black. Bradley was white. Montgomery frowned. Individual cases have distinguishing factors that statistics don't capture. The only distinguishing factor was race, Zoe said, her voice finally betraying emotion. Marcus was my brother. The revelation landed like a physical blow. Montgomery searched his memory, trying to recall the case among the thousands he'd presided over, but found only fragments. A slender teenager, a distraught mother, a public defender making standard arguments he'd dismissed. That was 5 years ago, he ventured. 6, Zoe corrected. Marcus served 18 months before being released on parole. While incarcerated, he was assaulted twice, missed his high school graduation, and lost his scholarship to State University. Bradley Thompson, meanwhile, completed a 6-month diversion program and is now in his 3rd year of medical school. Montgomery felt a strange hollowness in his chest. So this is personal for you. Of course it's personal, but it's also much bigger than my brother or me. She gestured toward the courthouse behind them. What happens in these rooms shapes lives, communities, generations. When justice is applied unevenly, it isn't justice at all. And you appointed yourself to fix the system? He asked, unable to keep the sarcasm from his voice. No, she replied simply. I decided to become part of the solution rather than remain a victim of the problem. Montgomery studied her face, composed, determined, but with an undercurrent of pain he hadn't noticed before. Not just an academic exercise or a political stunt, then. For Zoe Taylor, this was about a brother whose life had been derailed by a decision he'd made without a second thought. What happens now? He asked, surprising himself with the question. The commission will review the evidence and determine whether formal charges are warranted. You'll have the opportunity to respond. Witnesses may be called. The process typically takes 3 to 6 months. You seem very familiar with the procedure. I researched it thoroughly, she acknowledged. This isn't my first experience with the judicial system, as you now know. A heavy silence fell between them. In the distance, Montgomery could hear the faint sounds of traffic, of normal life continuing beyond the walls of the courthouse, while his own career hung in the balance. Why are you here today? He finally asked. The press conference is over. You won your case. Shouldn't you be celebrating with Professor Wright? Zoe's expression softened slightly. I'm here because this courthouse isn't just where my brother was sentenced or where I faced you yesterday. It's where I hope to work someday, as an attorney committed to equal justice. I needed to remind myself of that goal. She stood, gathering her notebook and bag. The Justice Project isn't about destroying careers, Judge Montgomery. It's about accountability and reform. What happens next depends largely on you. As she walked away, Montgomery remained on the bench, her words echoing in his mind. Accountability, reform, solutions rather than victims. For the first time since the press conference, his anger gave way to something more complicated, a creeping doubt about the certainty with which he'd always viewed his role in the justice system. Back in his chambers, he found Maria waiting with a stack of messages and a concerned expression. "Judge Carlton asked me to collect these for you," she said, placing a box of files on his desk. "Your cases from the past week for review." Montgomery nodded, still distracted by his encounter with Zoe. "There's something else," Maria added hesitantly. "Someone leaked your exchange with Ms. Taylor in court yesterday, the part where you questioned her legal knowledge. It's gone viral." She handed him her phone, open to a social media page where a video clip showed his dismissive questioning of Zoe's capabilities, followed by her composed response about his assumptions regarding a young black woman's knowledge of constitutional rights. The clip had over 200,000 views already, with thousands of comments, most criticizing him, some sharing similar experiences with judicial bias. "It's everywhere," Maria said apologetically. "All the local stations are running it, and the national outlets are picking it up now." Montgomery sank into his chair, the full impact of his situation finally hitting home. This wasn't going away. The careful reputation he'd built over decades was unraveling in real time, broadcast for the world to see. And the worst part was that he couldn't honestly say the criticism was unfounded. For the first time in his judicial career, Richard Montgomery found himself facing a truth he could not dismiss, evade, or rule against. A truth about himself that demanded a verdict he wasn't sure he was ready to render. 3 days after the viral video, Montgomery sat alone in his home office, surrounded by case files he'd brought from the courthouse. Since being temporarily removed from the bench, he'd found himself in an unsettling limbo, not suspended but effectively sidelined. Without the structure of daily court proceedings, he felt unmoored, his carefully ordered life suddenly adrift. The files before him represented a random sampling of his rulings from the past 5 years, cases he'd pulled himself after hours, when the courthouse was nearly empty. Not the high-profile ones that made the local news, but the routine matters that comprised the bulk of his docket. Bail hearings, plea agreements, sentencing decisions. The mundane machinery of justice that processed dozens of lives through his courtroom each week. He'd begun reviewing them the previous evening, intending to find evidence contradicting the Justice Project's accusations. Instead, as midnight approached and his reading glasses grew heavy on his nose, he found himself creating 2 piles on his desk, cases involving white defendants and those involving minorities. The disparities in outcomes, when laid bare this way, were difficult to dismiss. Montgomery poured himself another finger of bourbon, his third of the evening. The amber liquid caught the light from his desk lamp as he swirled it, watching the miniature whirlpool form and dissipate. His doorbell rang, an unexpected intrusion at 9:30 p.m. He considered ignoring it until a second ring, more insistent than the first, propelled him reluctantly from his chair. Judge Arthur Fleming stood on his porch, tall, silver-haired, with the ramrod posture of his military days before joining the judiciary. At 72, Fleming was the most senior judge in the district, a man whose approval Montgomery had sought throughout his career. "Arthur," Montgomery said, surprised, "I wasn't expecting you." "Clearly," Fleming replied, eyeing Montgomery's rumpled shirt and the tumbler still clutched in his hand. "May I come in?" Montgomery stepped aside, suddenly self-conscious about both his appearance and the state of his home, which showed the neglect of recent days. Mail piled on the entry table, dishes in the sink visible from the hallway. Fleming made no comment as he followed Montgomery to the living room, declining the offer of a drink with a small shake of his head. He settled into an armchair, studying Montgomery with the same penetrating gaze he employed from the bench. "You haven't been answering your phone," Fleming stated. "I've been preoccupied," Montgomery replied, setting his glass down untouched. "So I see." Fleming glanced toward the home office where files and legal pads covered every surface. "Carlton tells me you're not cooperating with counsel for the investigation." Montgomery stiffened. "I don't need someone to explain my own rulings to me." Pride was always your weakness, Richard, Fleming said with unexpected bluntness. It's what makes you a formidable jurist, but it may be your undoing now. I'm being railroaded by academics with an agenda. Montgomery protested, the familiar anger rising again. They've manipulated statistics to fit their narrative. And the video? Fleming asked quietly. Was that manipulated too? Montgomery had no answer. The clip continued to haunt him, his condescension nakedly apparent, the subtle contempt in his expression when questioning Zoe's legal knowledge. Worse, he recognized the same tone in his treatment of countless defendants over the years, a realization that had kept him awake the past 3 nights. Arthur, why are you here? He finally asked. To join the chorus telling me I've been an unconscionable bigot for 20 years? No, Fleming replied, his voice softening slightly. I'm here because 30 years ago, Judge Howard Brennan pulled me aside after I sentenced a young Puerto Rican man to 10 years for a crime nearly identical to one where I'd given a white defendant probation the week before. Montgomery stared at him, surprised by the personal disclosure from a man known for his professional reserve. Brennan showed me the transcripts side by side, Fleming continued. I told him there were distinguishing factors, mitigating circumstances, all the things we tell ourselves. He listened patiently, then asked me one question. Would you have reached the same decision if the defendants were reversed? It was the most important question anyone ever asked me as a judge. And what was your answer? Montgomery asked, though he suspected he knew. I didn't have one, Fleming admitted. At least, not one I could defend. It forced me to confront patterns in my decision-making I'd never acknowledged. Patterns rooted in my upbringing, my cultural background, my unconscious assumptions about who deserves leniency and who deserves the full weight of the law. Montgomery felt a strange hollowness in his chest. You're saying Wright and her project are right about me. I'm saying that none of us are immune to bias, Richard. The question is whether we have the courage to recognize it in ourselves and the humility to correct it. After Fleming left, Montgomery returned to his office, staring at the 2 piles of case files. He thought of Marcus Williams, the honor student whose potential had been derailed by his ruling, and Bradley Thompson, now in medical school after a nearly identical offense. Had the defendants been reversed, would his decisions have been the same? The next morning, Montgomery arrived at the courthouse early, not for any official duty but to meet with Sandra Diaz, the court's general counsel handling his case. Her office was small but immaculate, legal volumes precisely arranged on built-in shelves, her desk clear except for a single folder. His case, he presumed. Judge Montgomery, she greeted him, professional but not unfriendly. I wasn't expecting you until next week. I've been reviewing my cases, he said without preamble. I'd like to see the complete data set from the Justice Project's analysis. Diaz's eyebrows rose slightly. May I ask why? To understand the full scope of what they're alleging. If I'm going to respond to these accusations, I need to see everything, not just their selected examples. She studied him for a moment, then nodded. I'll have it sent to you. The Commission would view your engagement with the evidence as a positive development. I'm not conceding anything, Montgomery clarified quickly. I simply want all the facts. Of course, Diaz replied, a hint of knowing in her tone that irritated him. There's something else you should be aware of. The Justice Project has filed a motion for review of sentences in 43 cases from your court, including State v. Williams. Montgomery felt his stomach tighten. On what grounds? Equal protection violations under the 14th Amendment, citing the statistical evidence of disparate treatment. She hesitated, then added, Judge Carlton has assigned the motion to Judge Fleming. Of course. Fleming's visit hadn't been merely personal concern then. The older judge was now responsible for reviewing Montgomery's most controversial rulings. a fact he had diplomatically omitted from their conversation. "When does the review begin?" Montgomery asked. "Next week. The first 10 cases have been scheduled for Thursday." Diaz consulted her calendar, including the Williams case. As Montgomery left her office, he found himself walking not toward the exit, but down the corridor to courtroom 15B. His courtroom, at least nominally. The door was unlocked. Inside, the room was dim, illuminated only by the morning light filtering through half-closed blinds. He moved slowly to the bench, his hand trailing along the polished wood surface that had been the source of his authority for so many years. From this elevated position, he had pronounced thousands of judgments, each delivered with the certainty that he was serving justice. How many of those judgments, he now wondered, had been tainted by the very biases he'd so confidently denied? He thought again of Zoe Taylor standing before him, of her composure in the face of his condescension, of her revelation about her brother. Most of all, he thought of her words in the courthouse garden. "I decided to become part of the solution rather than remain a victim of the problem." As Montgomery descended from the bench, he noticed a young law clerk entering the courtroom with a stack of files, preparing for the day's proceedings under whatever judge had been assigned to replace him. "Judge Montgomery," the clerk said, surprised. "I didn't expect to see you here." "Neither did I," Montgomery replied quietly, more to himself than to the clerk. He straightened his shoulders and headed for the exit, a decision crystallizing in his mind. If his career was to be judged, and it most certainly would be, he wanted to face that judgment with the complete truth, however uncomfortable it might be. For the first time since the Justice Project's press conference, Richard Montgomery felt something like clarity. He didn't know if his judicial career could or should be salvaged, but he was finally ready to ask himself the question Fleming had posed. Would he have ruled differently if the defendants had been reversed? And more importantly, he was ready to hear the answer. The Justice Center's third-floor conference room had been transformed into a makeshift hearing space for the sentence review proceedings. Unlike the formal grandeur of courtroom 15B, with its polished oak and imposing bench, this room was utilitarian, a long rectangular table surrounded by standard office chairs, with additional seating arranged along the walls for observers. The fluorescent lighting cast everything in a harsh, unforgiving glow. Montgomery entered precisely at 9:45, 15 minutes before the scheduled start. He had deliberated extensively over his appearance today, not as the presiding judge but as the subject of review. In the end, he'd chosen a conservative charcoal suit rather than any outfit that might suggest judicial authority he no longer wielded. Still, he found himself instinctively heading for the head of the table before redirecting to a seat along the side, facing the door. He wasn't surprised when Zoe Taylor arrived shortly after, accompanied by Professor Wright. What did surprise him was the young man who followed them, tall and slender with Zoe's same determined eyes, though his carried a wariness that made him appear older than his 23 years. Marcus Williams. The honor student Montgomery had sentenced to 3 years for marijuana possession 6 years ago. The brother whose case had set Zoe on her path to the Justice Project. Montgomery had reviewed the Williams file repeatedly over the past week, searching for the factors that had led to his decision. The official record showed little to justify the harsh sentence. No prior convictions, positive character references from teachers, stable family support. The only hint came in Montgomery's own sentencing remarks, where he had emphasized the need for deterrence in communities where drug activity is prevalent, a thinly veiled reference to the predominantly black neighborhood where Williams lived. Seeing the young man in person stirred an uncomfortable feeling in Montgomery's chest. Williams walked with the slightly hunched posture of someone who had learned to make himself less noticeable, his eyes scanning the room as if assessing potential threats, habits likely formed during his 18 months of incarceration. More people filtered in, Professor Bennett and several Justice Project staff, court personnel, a few reporters who had been granted access, and finally Judge Fleming, who entered with the measured gravity that had earned him the nickname the Admiral among courthouse staff. "Good morning," Fleming began, his voice commanding immediate attention. "We are here to review State v. Marcus Williams, case number CR 2019-4873, pursuant to the motion filed by the Justice Project citing equal protection concerns under the 14th Amendment." He nodded to Professor Wright. "As counsel for Mr. Williams, you may proceed." Wright rose, her elegant bearing and precise diction reflecting decades in courtrooms across the state. "Your Honor, we are seeking a review of Mr. Williams's sentence based on statistical evidence of disparate treatment in Judge Montgomery's courtroom, as well as direct comparison with similar cases from the same time period." She gestured to a paralegal, who distributed bound presentations to everyone present. The most telling comparison is with State v. Bradley Thompson, case number CR 2019-4892, heard by Judge Montgomery just 3 days after Mr. Williams's case. Both defendants were 17. Both were charged with possession with intent to distribute marijuana in amounts less than 1 ounce. Both were first-time offenders on adult charges. Wright flipped to a comparison chart. The similarities end there. Mr. Williams, who is black, was denied youthful offender status despite having no prior juvenile record and maintaining a 3.7 GPA. He received a 3-year sentence. Mr. Thompson, who is white, was granted youthful offender status despite having 2 prior juvenile adjudications. He received a 6-month diversion program with no incarceration. Montgomery kept his expression neutral as Wright methodically laid out dozens of similar comparisons from his docket. Cases where white defendants consistently received more lenient treatment than minorities with equivalent or lesser charges. The evidence presented in this stark side-by-side format was damning. Mr. Williams served 18 months before parole, Wright continued. During that time, he was assaulted twice, resulting in a broken rib and facial lacerations requiring 12 stitches. He lost his scholarship to State University. Upon release, his felony record prevented him from securing stable employment for nearly a year. Wright's presentation continued for 40 minutes, building an overwhelming case for bias in Montgomery's sentencing patterns. When she finished, Fleming turned to the state's representative, a young assistant attorney general named Patel. "The state acknowledges the statistical disparities presented," Patel began, surprising Montgomery. "While we cannot speak to Judge Montgomery's intent in individual cases, we do not oppose a review of Mr. Williams's sentence in light of the comparative data." Fleming nodded, then addressed Montgomery directly. "Judge Montgomery, while you are not obligated to make a statement at this proceeding, you may do so if you wish." Montgomery felt every eye in the room turn to him. He had prepared remarks, carefully written and rewritten over several days. But as he looked at Marcus Williams's face, those prepared words suddenly seemed inadequate, even cowardly. "I would like to speak," he said, standing slowly. "Not as a judge defending his record, but as someone who has been forced to confront uncomfortable truths about his own decision-making." The room fell silent. Even Wright looked surprised by his tone. "I've spent the past week reviewing not only Mr. Williams' case, but dozens of others from my docket. I've examined the patterns in my rulings with as much objectivity as I could muster." Montgomery paused, gathering himself. "The data is clear. Defendants of color in my courtroom received harsher sentences than white defendants for equivalent crimes. I cannot in good conscience attribute this to coincidence or to factors not reflected in the record." A murmur ran through the observers. This was not the defiant denial they had expected. "In Mr. Williams' case specifically," Montgomery continued, turning to face the young man directly, "I can find no legitimate justification for the sentence I imposed or for denying youthful offender status while granting it to Mr. Thompson days later. The disparity reflects bias that I failed to recognize in myself at the time. The admission hung in the air, its weight almost tangible in the suddenly still room. Marcus Williams' expression remained carefully neutral, but Zoe's eyes had widened slightly, her composure briefly slipping to reveal genuine surprise. "I do not expect this acknowledgement to undo the harm caused by my ruling," Montgomery added. "Mr. Williams lost opportunities and endured hardships that cannot be reversed. But I believe the court should grant the relief sought in this motion, and I extend my personal apology to Mr. Williams for the injustice he suffered in my courtroom." As Montgomery sat down, he felt oddly lightened, as though speaking the truth aloud had released some long-carried burden. The sensation was so unfamiliar that it took him a moment to identify it. Not the absence of pride, as he might have feared, but the presence of integrity. Judge Fleming studied him thoughtfully before speaking. "The court appreciates your candor, Judge Montgomery. Based on the evidence presented and the positions of all parties, I am vacating the original sentence in State v. Williams and ordering the record expunged pursuant to youthful offender provisions that should have been applied initially." He turned to Marcus. "Mr. Williams, while the court cannot restore the opportunities lost or erase the hardships you endured, it can acknowledge the injustice and attempt to clear the path forward. Your record will be expunged within 30 days, and you will no longer be subject to the collateral consequences of this conviction." After Fleming adjourned the proceeding, Montgomery remained seated as others filed out. He noticed Marcus Williams in conversation with Professor Bennett near the door, their heads bent together over some document. Zoe stood nearby, her gaze occasionally flicking toward Montgomery, with an expression he couldn't quite read. Finally, as the room emptied, she approached his table. "That couldn't have been easy," she said simply. "It wasn't," Montgomery admitted, "but it was necessary." "Why now? After all these years of defending your rulings?" Montgomery considered the question. "Judge Fleming asked me if I would have made the same decisions if the defendants had been reversed. Once I forced myself to answer honestly, I couldn't continue the pretense." Zoe nodded slowly. 9 more cases are scheduled for review tomorrow." "I know. I'll be here for each one." She studied him for a moment longer, then said something that surprised him. "This was never about destroying you, you know. It was about justice, for my brother and for all the others who didn't have someone to fight for them." As she turned to leave, Montgomery found himself wondering what might have happened if he'd encountered Zoe Taylor years earlier, not as an adversary exposing his biases, but as a reminder of the principles he'd once believed he embodied as a judge. Perhaps then, Marcus Williams and countless others might have received the justice they deserved the first time they entered his courtroom. Montgomery's admission reverberated through the courthouse with the force of a thunderclap. By the following morning, video of his statement had joined the earlier clip online, creating a stark contrast. The arrogant judge dismissing Zoe's legal knowledge juxtaposed with his humble acknowledgement of bias days later. Legal blogs dissected his words, judicial watchdog groups cited them as precedent, and courthouse staff exchanged theories about what had prompted his unexpected turn. In the judge's private dining room, Montgomery found himself the object of wary glances and hushed conversations that abruptly ceased when he approached. He selected a small table in the corner, preparing to eat lunch alone, when Judge Fleming unexpectedly joined him. "Quite a stir you've caused," Fleming remarked, unfolding his napkin with military precision. "3 judges have called me since yesterday, concerned you've set a dangerous precedent." "For acknowledging error?" Montgomery asked, pushing his salad around his plate. "For validating statistical analysis of judicial decisions," Fleming replied. "You've made a lot of people nervous, Richard. Judges who've never had to question their own patterns before." "Perhaps they should be nervous," Montgomery said quietly. I've reviewed 9 more cases since yesterday. The disparities are consistent throughout. Fleming studied him thoughtfully. You know, when I first heard about the Justice Project's investigation, I assumed you'd fight it tooth and nail. The Richard Montgomery I've known for 20 years would never concede an inch, let alone publicly acknowledge bias. The Richard Montgomery you've known was living in a carefully constructed bubble of self-righteousness, Montgomery replied, surprising himself with the candor. It took seeing the evidence laid out systematically and coming face to face with Marcus Williams to finally penetrate that bubble. It's not an easy thing confronting one's own failings, Fleming observed. It's considerably easier than continuing to deny what's plainly true, Montgomery said, though I don't expect everyone to see it that way. As if on cue, Judge Wilson Patterson entered the dining room, spotted Montgomery, and made a show of choosing a table at the opposite end. Patterson had been a vocal critic of the Justice Project from the beginning, dismissing their methodology as academic overreach into judicial independence. Wilson's worried he's next, Fleming commented, noticing the deliberate snub. His sentencing statistics apparently make yours look positively egalitarian. Is that supposed to make me feel better? Montgomery asked. Not at all. Just an observation that the institutional resistance to this kind of scrutiny runs deep. Fleming set down his fork. The question now is what happens next, for you personally and for the system more broadly. Montgomery had been asking himself the same question since his admission in yesterday's hearing. The 9 additional cases scheduled for review today would likely result in similar outcomes: vacated sentences, expunged records, judicial acknowledgments of error. But what about the hundreds of other defendants whose cases weren't being reviewed? What about the ongoing practices in courtrooms across the district? Before he could respond, he noticed Zoe and Marcus entering the dining room, accompanied by Professor Bennett. They were likely preparing for the afternoon's hearings. As they crossed to a table, Montgomery saw several judges watching them with undisguised hostility, the interlopers threatening the judicial establishment. "Excuse me," Montgomery said to Fleming, standing abruptly. He walked directly to their table, aware of the eyes following his movement. "Ms. Taylor, Mr. Williams, Professor Bennett," he greeted them. "May I join you briefly?" Bennett looked surprised but gestured to an empty chair. "Of course, Judge Montgomery." "I've been reviewing the cases scheduled for this afternoon," Montgomery began without preamble. "There's no need to subject each defendant to a full hearing. I'm prepared to stipulate to the relief sought in all 9 cases and any others where the Justice Project has identified similar disparities." Bennett exchanged glances with Zoe. "That's unexpected," he said carefully. "Why?" Marcus asked, speaking directly to Montgomery for the first time. His voice was deeper than Montgomery had anticipated, with an intensity that commanded attention. "Why am I stipulating?" Montgomery clarified. "Why now?" Marcus pressed. "After years of these sentences, after lives have been derailed, why the sudden change of heart?" It was a fair question, one that demanded more than platitudes about seeing the error of his ways. Montgomery considered his answer carefully, aware of the dining room's unusual quiet as others strained to overhear. "Because I was wrong," he said simply. "Not just in individual rulings, but in my fundamental approach to judging. I've spent my career believing I was impartial while blind to the biases informing my decisions. I can't undo the harm that's caused, but I can stop perpetuating it." Marcus studied him, skepticism evident. "So you expect us to believe you've had some sort of judicial epiphany?" "I don't expect you to believe anything about me personally," Montgomery replied, "but I am offering to formally acknowledge the bias in these cases without requiring each defendant to endure a public hearing. That acknowledgement will be on the record, and the relief will be the same." Zoe, who had been watching this exchange intently, finally spoke. What about the cases not currently under review? The Justice Project identified over 200 defendants who received demonstrably disparate sentences in your courtroom. I'm prepared to review all of them, Montgomery said, starting with the most recent and working backward to the statute of limitations. Bennett leaned forward. You understand what you're proposing? The scale of it? I do, Montgomery confirmed. I also understand it's the bare minimum required by justice. After they discussed logistics, Montgomery returned to his table where Fleming waited, eyebrows raised questioningly. You're voluntarily opening the floodgates, Fleming observed. Patterson and his allies will say you've lost your mind. Perhaps I found it instead, Montgomery replied. That afternoon, instead of 9 separate hearings, Judge Fleming presided over a consolidated proceeding where Montgomery formally stipulated to the relief sought in all pending cases. The courtroom was packed, with reporters filling the back row and defendants and their families occupying most remaining seats. For the record, Montgomery stated, I acknowledge that each of these sentences reflected disparate treatment based on race, unsupported by legitimate legal distinctions between cases. I request that the court vacate these sentences and expunge the related convictions. Fleming granted the motions, but added an unexpected directive. In light of Judge Montgomery's acknowledgement and the evidence presented by the Justice Project, I am ordering a comprehensive review of sentencing patterns across all criminal courts in this district to be conducted by an independent panel including judicial, academic, and community representatives. A murmur ran through the courtroom. Fleming was expanding the scope beyond Montgomery's individual cases to the entire system, a move that would send shockwaves through the judiciary. As the proceeding concluded, Montgomery found himself face to face with a young woman whose sentence he had just acknowledged as biased, Maya Rodriguez, who had served 2 years for a nonviolent offense while white defendants with identical charges received probation. I lost my housing, my job, and 2 years with my daughter, she told him, her voice steady despite the emotion evident in her eyes. The expungement helps moving forward, but it doesn't give me back what I lost. I know, Montgomery replied, the inadequacy of his response painful even to his own ears. Nothing I can say will restore those losses. Then don't say anything, she advised. Do something instead. You have power in this system. Use it to make sure this doesn't happen to someone else's daughter. Her words stayed with him as he left the courthouse that evening. In the plaza outside, he noticed Zoe deep in conversation with Professor Wright near the bottom of the steps. On impulse, he approached them. Ms. Taylor, he called. A moment, if you have one. Wright raised an eyebrow but stepped away, giving them privacy. Maya Rodriguez is right, Montgomery said without preamble. Acknowledging past injustice isn't enough. I need to actively work towards systemic change. Zoe studied him, her initial suspicion gradually giving way to cautious consideration. What are you proposing? I'm not sure yet, he admitted. But I'd like to meet with you and your colleagues at the Justice Project to discuss possibilities. My perspective from inside the system, combined with your data and advocacy, might be effective. For the first time since he'd met her, Zoe's expression softened into something approaching a smile. Judge Montgomery, that might be the most equitable proposal you've ever made. As they discussed meeting details, Montgomery realized that for the first time in weeks, he felt something like purpose returning, not the brittle authority he'd wielded from the bench, but something more authentic and perhaps more valuable, the opportunity to rebuild a career dedicated to actual justice rather than merely its appearance. The Justice Project occupied the 3rd floor of a converted warehouse in the city's arts district. The space was open and airy, with exposed brick walls and large windows, nothing like the wood-paneled formality of the courthouse. Student volunteers worked at clustered desks, while paralegals and attorneys conferred in glass-walled meeting rooms. The energy was palpable, purposeful, urgent, collaborative. Montgomery felt immediately out of place in his tailored suit and polished Oxfords. Every head turned as Zoe led him through the main workspace toward a conference room at the back. The conversations didn't stop, but they quieted, eyes following his progress with undisguised curiosity and, in some cases, hostility. "You're the first judge to ever set foot in here," Zoe explained, sensing his discomfort. "Most of our volunteers have spent considerable time watching their loved ones receive inequitable treatment in courtrooms like yours." "I understand," Montgomery replied quietly. He did now. Understood that each person here represented stories like Marcus's and Maya's. Understood that his presence might feel like an intrusion into a space created precisely because the formal justice system had failed them. The conference room contained a long table surrounded by mismatched chairs, clearly furnished on a non-profit budget. Professors Wright and Bennett were already seated, along with two attorneys Montgomery didn't recognize. To his surprise, Marcus Williams was also present, a laptop open before him. "Marcus is our data analyst," Wright explained, noting Montgomery's questioning glance. "He designed much of the statistical methodology we use to analyze your sentencing patterns." Montgomery absorbed this information with newfound respect. "Impressive work," he acknowledged, taking a seat. "The analysis was irrefutable." "That was the point," Marcus replied, his tone neutral but not hostile. "To create a data set that couldn't be dismissed as anecdotal or cherry-picked." Bennett gestured to the unfamiliar attorneys. "Judge Montgomery, this is Carmen Diaz, our lead impact litigation counsel, and Michael Chen, who heads our legislative advocacy team." Montgomery nodded to each of them. "Thank you for agreeing to meet. I recognize that my presence here may be complicated for your organization." "That's putting it mildly," Diaz said frankly. "Half our staff thinks this is a publicity stunt or an attempt to undermine our work from within." "And the other half?" Montgomery asked. "Is willing to see if your conversion is genuine," Chen replied. "Though conversion might be the wrong word. We're not a church, Judge Montgomery. We don't require belief, just concrete action." Wright directed everyone's attention to a whiteboard where she had outlined an agenda. "We have 3 objectives today. First, to discuss the ongoing case reviews from Judge Montgomery's docket. Second, to consider his potential role in the district-wide review ordered by Judge Fleming. And third, to explore longer-term systemic reforms." For the next 2 hours, Montgomery found himself in a different kind of legal proceeding, one where he wasn't the authority but a participant, where passionate advocacy wasn't contained by courtroom formalities, where the goal wasn't winning a case but solving a fundamental problem. It was both unsettling and exhilarating. "The case reviews are proceeding efficiently," Zoe reported, referencing a spreadsheet projected on the wall. "With Judge Montgomery's stipulations, we've been able to process 47 cases in the past week. At this rate, we can complete the initial 200 identified cases within 2 months." "What about cases beyond those 200? Montgomery asked. "My initial review suggests the pattern extends further back." Diaz looked skeptical. "You're proposing to review your entire judicial record? That's over 15,000 criminal cases." "Not all would show disparities," Montgomery clarified. "But yes, I believe a comprehensive review is warranted." "With what resources?" Chen asked practically. "The Justice Project has limited staff, and the court system isn't exactly enthusiastic about this process. I've spoken with Sandra Diaz about establishing a dedicated review unit within the court," Montgomery replied. "Using court resources to address judicial errors would be appropriate, in my view." Bennett leaned forward. "And you think the administrative judges will approve this?" "I think they'll find it preferable to class action litigation challenging thousands of sentences simultaneously," Montgomery said dryly. "Which I understand is Ms. Diaz's specialty." Carmen Diaz smiled for the first time. "You've done your homework, Judge." The discussion turned to the district-wide review Fleming had ordered. Wright explained that the administrative judges were already pushing back, arguing judicial independence and questioning the methodology. "They're doing exactly what I did initially," Montgomery acknowledged, defending the system rather than examining it. "The difference is that now they're facing both the data and a judge who's acknowledged its validity." "Which brings us to your potential role," Wright said. "Judge Fleming is assembling the review panel. Your participation would send a powerful message." Montgomery considered this. "It would also generate significant resistance. Many of my colleagues already see me as a traitor to the bench." "Is that stopping you?" Zoe asked directly. He met her gaze. "No, but I want to be strategic about how I can be most effective." The most challenging discussion came when they turned to long-term reforms. Chen presented legislative proposals to change sentencing guidelines, require implicit bias training for judges, and establish community oversight for judicial performance. "These are all valuable initiatives," Montgomery said carefully, "but they don't address a fundamental issue, judicial culture. The bench sees itself as beyond reproach, insulated from criticism by necessity. That insulation becomes a breeding ground for unchecked bias." "And how do you propose to change a culture you've been part of for decades?" Marcus asked, his first direct question of the meeting. Montgomery didn't have a ready answer. "I'm still figuring that out," he admitted. "But I know it requires more than training sessions or oversight committees. It requires a foundational shift in how judges understand their role and responsibility." As the meeting concluded, Montgomery felt both drained and invigorated. They had established concrete next steps. He would join Fleming's review panel, continue the case-by-case stipulations, and work with Chen on a judicial accountability framework that might actually gain traction with his colleagues. As the others filed out, Zoe remained behind, studying him with that searching gaze he'd first encountered in his courtroom. "May I ask you something?" she said finally. "Of course." "What changed, really? Because people don't typically dismantle their entire worldview overnight, especially not successful people with power." Montgomery considered the question carefully. "It wasn't overnight, though it might appear that way from the outside. The seeds were planted the moment you stood in my courtroom, and I made assumptions about your capabilities based solely on your appearance. Your composure in the face of my condescension forced me to see myself clearly for the first time in years." "And you didn't like what you saw?" Zoe suggested. "No," Montgomery agreed quietly. "I didn't." 2 days later, Montgomery's collaboration with the Justice Project became public knowledge when Judge Fleming announced the composition of the district-wide review panel. The headline in the Law Journal said it all. "Montgomery joins judicial bias investigation. Poacher turned gamekeeper." The backlash from his colleagues was swift and harsh. Judge Patterson circulated a letter, signed by 7 other judges, condemning Montgomery's capitulation to activist pressure and warning of dangerous precedents for judicial independence. 3 judges refused to acknowledge him in the courthouse corridors. His usual lunch table in the judge's dining room remained conspicuously empty. Judge Carlton called him to his office, his expression grave. "You're putting me in an impossible position, Richard. Half the bench is demanding I remove you from the review panel, claiming conflict of interest. The other half thinks your participation makes the whole process look like an admission of systemic failure." "It is a systemic failure," Montgomery replied calmly. "My individual biases didn't develop in a vacuum. They were shaped and reinforced by institutional practices that remain unchallenged." Carlton sighed heavily. "You've become quite the reformer for someone who was denying the existence of bias 2 weeks ago." "I prefer to think of it as intellectual honesty," Montgomery said. Once I accepted the evidence regarding my own rulings, I couldn't logically deny the broader implications. As he left Carlton's office, Montgomery found Maria waiting for him, her expression concerned. "Judge, there's something you should see." She handed him a printout of an email that had apparently been circulating among court staff, a candid photograph of him entering the Justice Project's offices, accompanied by derisive comments questioning his loyalty and judgment. "It's all over the courthouse," Maria said quietly. "They're saying you've betrayed the judiciary." Montgomery studied the printout, feeling the weight of his colleagues' disapproval, but also the strange lightness that had accompanied his recent decisions. "Perhaps," he replied, handing the paper back to her, "but I'm no longer betraying justice, and that makes all the difference." The first formal meeting of the Judicial Practices Review Panel took place in the grand jury room of the federal courthouse, neutral territory chosen deliberately to avoid the appearance of either judicial control or activist influence. Montgomery arrived early, watching as the diverse group assembled. 3 judges, including Fleming, 2 law professors, including Bennett, 3 community representatives selected through a civic organization, and 2 practicing attorneys, 1 prosecutor, 1 defense counsel. The Justice Project was represented by Professor Wright and, somewhat controversially, Zoe Taylor. The tension was palpable as Judge Patterson entered, having been appointed to represent the contingent of judges opposed to the review. He pointedly took a seat at the opposite end of the table from Montgomery, acknowledging him with only the briefest of nods. Judge Fleming called the meeting to order, his authoritative presence immediately establishing a tone of seriousness. "This panel has been convened with a specific mandate: to examine sentencing patterns across our district for evidence of disparate treatment based on race, ethnicity, or socioeconomic factors. Our goal is not to assign individual blame, but to identify systemic issues and recommend concrete reforms." Patterson's skepticism was evident in his posture, arms crossed, jaw set. "Before we proceed, I'd like to register my concern about the composition of this panel. The inclusion of individuals with clear advocacy agendas compromises our objectivity." His gaze flicked meaningfully toward Zoe and the community representatives. "On the contrary," Fleming replied evenly, "the inclusion of diverse perspectives ensures we don't merely reinforce our own institutional blind spots. Each member was selected precisely because they bring a different lens to this examination." Wright stepped in smoothly. "Perhaps we could begin by reviewing the preliminary data, which speaks for itself regardless of who's interpreting it." She distributed comprehensive binders containing statistical analyses of sentencing across the district's 12 criminal court judges over the past 5 years. The data had been meticulously broken down by race, gender, age, type of offense, and socioeconomic indicators. "As you can see," Wright continued, "while Judge Montgomery's disparities were significant, they weren't unique. Every judge in the district shows some degree of racial disparity in sentencing, ranging from 12% to 61% longer sentences for minority defendants compared to white defendants with equivalent charges and criminal histories." Patterson leaned forward. "These so-called disparities could be explained by numerous factors not captured in your analysis: defendant's demeanor, quality of legal representation, strength of evidence, each of which could themselves reflect systemic inequities," Montgomery interjected. "The question isn't whether these disparities exist. The data clearly shows they do. The question is why and what we can do about them." Patterson's expression hardened. "Easy for you to say, Richard. You've already conceded the point and compromised your judicial integrity in the process." "On the contrary," Montgomery replied calmly, "I've reclaimed my integrity by acknowledging what the evidence plainly shows." The exchange set the tone for what would become a weekly battle, with Patterson and his allies working to minimize or explain away disparities that Montgomery and others insisted must be confronted directly. Yet despite the contention, the panel made steady progress. They interviewed dozens of participants in the system, from public defenders to probation officers, and reviewed hundreds of case files in granular detail. 3 weeks into the process, Montgomery found himself working late at the Justice Project office, reviewing transcripts with Zoe and Marcus. The cavernous space was quiet at this hour, most volunteers and staff having departed. The three of them had developed an effective working rhythm, with Marcus identifying statistical anomalies, Zoe parsing legal patterns, and Montgomery providing insider context on judicial decision-making. "This case is particularly telling," Marcus said, sliding a transcript across the table. Judge Friedman gave a white defendant probation for assault, citing his potential and family support, while sentencing a Latino defendant to 2 years for an identical charge the same day, emphasizing community safety and deterrence. Montgomery reviewed the documents, recognizing the judicial language that masked bias behind seemingly neutral considerations. "These are the phrases we're taught to use," he acknowledged. "They sound like legitimate factors, but they're often proxies for race and class judgments." "How do you mean?" Zoe asked, looking up from her notes. "Potential is assessed based on educational credentials, employment, family structure, all factors influenced by systemic advantages. Community safety often translates to concerns about certain neighborhoods, which maps directly onto racial demographics." Montgomery shook his head. "I used these exact phrases for years without questioning the assumptions behind them." Marcus studied him thoughtfully. "Did you ever consider these issues before the Justice Project came after you?" The directness of the question might have offended Montgomery weeks ago. Now he appreciated the candor. "Not in any meaningful way," he admitted. "I would have said I treated everyone equally, but I never examined what equally meant in a system with deep structural inequities." Zoe exchanged a glance with her brother. "Most judges still don't," she observed. "Patterson and his allies are fighting this review like their careers depend on it." "In a way they do," Montgomery replied. "Not their positions, but their self-conception. It's devastating to realize you've been perpetuating harm while believing you were administering justice." Their conversation was interrupted by Montgomery's phone. The caller ID showed Judge Carlton's number, unusual at 9:30 p.m. "Richard," Carlton said without preamble when Montgomery answered. "There's been a development. Patterson has filed a motion with the Judicial Conduct Commission claiming you violated confidentiality by sharing internal court data with the Justice Project." Montgomery put the phone on speaker so Zoe and Marcus could hear. "What internal data? Everything we're using was obtained through proper channels or public records requests. He's claiming you provided them with judges' private notes and draft opinions that weren't part of the official record. He's demanding you be removed from the panel and that the Justice Project be excluded from the review process." Montgomery met Zoe's alarmed gaze across the table. "That's absurd. I've shared no such documents." "Nevertheless, the Commission has agreed to hear the complaint on an expedited basis. There's a closed session tomorrow morning at 8 CRA." Carlton's voice lowered. "Richard, if they find against you, it could end more than just your participation in the panel. Your judicial career would effectively be over." After the call ended, the three sat in stunned silence before Marcus spoke. "This is a setup. They're trying to discredit both you and our data." "They can't win on the merits, so they're attacking the process," Zoe agreed. "But how could Patterson think this would work? We've documented every source." Montgomery was already reviewing mental timelines. "Because he knows something we don't yet, something that makes him confident enough to risk filing a false complaint." He stood abruptly. "I need to get to the courthouse, right now." "We're coming with you," Zoe said, already gathering her things. "No," Montgomery countered. "If Patterson or his allies see you there, it will only reinforce their narrative about improper collaboration. I need to handle this alone." The courthouse was eerily quiet at night, skeleton security staff nodding to Montgomery as he made his way to his chambers. He had a theory forming, one that made his stomach clench with apprehension. When he reached his office, he went straight to his computer and accessed the audit logs for the court's document management system. It took nearly an hour of painstaking review, but eventually he found it. Evidence that someone had accessed confidential judicial documents using his credentials 2 weeks earlier, at times when he had been publicly documented at Justice Project meetings. Someone had used his login to access exactly the kind of materials Patterson was now accusing him of leaking. His phone rang again, Zoe, checking on his progress. He explained what he'd discovered. "This is serious," she said. "They're not just trying to discredit you. They're potentially committing criminal acts to obstruct the review. The question is, who has both the access and motivation?" Montgomery mused. "Someone who feels threatened by what the review might reveal," Zoe suggested. "Someone with more to hide than the average sentencing disparity." Montgomery continued searching the logs, focusing now on which specific documents had been accessed. The pattern that emerged sent a chill through him. They weren't random files, but targeted searches of cases involving defendants, represented by public defenders who had later filed misconduct complaints. Cases where evidence might have been suppressed or constitutional rights violated. "They're not just worried about sentencing disparities," he realized aloud. "Someone's concerned we might uncover actual misconduct beyond bias, Brady violations, due process issues, maybe worse." "We need to secure that evidence before the hearing tomorrow," Zoe urged. "If they're willing to frame you for leaking documents, they might be willing to destroy evidence too." Montgomery felt the weight of the situation pressing down on him. This wasn't just about his reputation or career anymore. It was about preventing a deliberate obstruction of justice by the very people entrusted to uphold it. "I'll contact Carlton and Fleming," he decided. "We need to secure the servers and access logs immediately." As he hung up, Montgomery caught his reflection in his office window, no longer the arrogant judge who had dismissed Zoe Taylor in his courtroom, but a man who had discovered that real justice sometimes required standing against the very institution he had once believed beyond reproach. Tomorrow's hearing wouldn't just determine his fate, it would reveal whether the system was capable of policing itself, or whether, as the Justice Project had long maintained, the machinery of justice sometimes worked hardest to protect its own power at the expense of those it claimed to serve. The Judicial Conduct Commission hearing room was smaller than a standard courtroom, with a curved table where 5 commissioners sat facing a single chair for the subject of inquiry. No gallery, no jury box, no court reporter's station, just an audio recording system and a space designed for private deliberation rather than public spectacle. Montgomery sat alone at the respondents' table, deliberately arriving without counsel to underscore his confidence in the evidence he'd gathered overnight. Judge Patterson sat across the room, flanked by 2 attorneys, and looking more satisfied than a man filing a serious complaint against a colleague had any right to be. Chief Commissioner Wallace, a retired Supreme Court justice known for her no-nonsense approach, called the session to order promptly at 8 a.m. This emergency hearing concerns allegations that Judge Richard Montgomery violated judicial confidentiality by sharing non-public court documents with third parties, specifically members of the Justice Project. She turned to Patterson. "Judge Patterson, as the complainant, please present your evidence." Patterson's lead attorney stepped forward, distributing folders to each commissioner. These documents were found in the Justice Project's offices, specifically draft opinions and bench notes that were never part of the public record. The timestamps and metadata indicate they were accessed using Judge Montgomery's credentials during periods when he was known to be meeting with Justice Project staff. Montgomery watched the commissioners review the materials, their expressions unreadable. When they finished, Wallace turned to him. "Judge Montgomery, how do you respond to these allegations?" with evidence of a deliberate attempt to obstruct justice and frame me for misconduct I did not commit," Montgomery replied, rising and approaching the commissioner's table with his own folders. "These are the complete audit logs from the court's document management system. They confirm that my credentials were indeed used to access these documents, but at times when I was demonstrably elsewhere, as confirmed by security camera footage, electronic keycard logs, and public appearances." He distributed a second set of documents. "This timeline correlates the unauthorized access with my documented whereabouts, proving someone else used my login information. I've also included evidence that the specific documents accessed relate to cases where serious judicial misconduct may have occurred, Brady violations, due process issues, potentially exculpatory evidence withheld from defendants." Patterson's face flushed with anger. "This is absurd. You're trying to distract from your own misconduct by making wild accusations." "Against whom?" Montgomery interrupted calmly. "I haven't accused anyone specifically, Judge Patterson, though your reaction is noteworthy." Commissioner Wallace studied the logs carefully. "These certainly appear to establish unauthorized access, but how would someone obtain your credentials, Judge Montgomery?" "That question led me to request a review of the courthouse security footage," Montgomery replied, producing a USB drive. "With Judge Carlton's authorization, obtained at 2 a.m. this morning, I can now answer that question definitively." The commissioners viewed the footage on a monitor, watching as a figure entered Montgomery's chambers after hours, sat at his computer, and methodically searched through files. The timestamp matched the audit logs exactly. When the figure turned toward the camera, Commissioner Wallace gasped audibly. "Judge Lawrence Hoffman," she identified, naming the administrative judge for criminal division, Patterson's mentor and closest ally on the bench. Patterson stood abruptly. "This proves nothing. Lawrence was probably just reviewing cases in his administrative capacity." At 11:30 p.m., using another judge's credentials, accessing only cases with potential misconduct flags, Montgomery countered. "The footage shows him downloading files to a USB drive, the same files that mysteriously appeared at the Justice Project offices, planted there overnight." He produced one final document. "And here is the security footage from the Justice Project building, showing Judge Hoffman entering with a key card registered to a courthouse maintenance worker, just hours after accessing my computer." The room fell silent as the implications sank in. This wasn't just about biased sentencing or individual misconduct. This was conspiracy and obstruction at the highest levels of the district judiciary. "I believe," Montgomery said into the silence, "that what we're witnessing is an attempt to derail the entire judicial review process by discrediting me and the Justice Project. The question is, why these particular cases triggered such an extreme response?" Commissioner Wallace turned to Patterson, whose confident demeanor had evaporated. "Judge Patterson, did you have knowledge of Judge Hoffman's actions when you filed this complaint?" Patterson's eyes darted between the commissioners and the door. I need to consult with counsel before responding further." "I think that answers the question," Wallace observed dryly. She conferred briefly with the other commissioners before addressing Montgomery. "Judge Montgomery, this commission finds no evidence of misconduct on your part. In fact, your diligence in uncovering this apparent conspiracy is commendable. We will refer this matter to the FBI for criminal investigation, as it appears to involve evidence tampering and obstruction of justice." She turned to Patterson. "As for you, Judge Patterson, consider yourself under investigation as well. This hearing is adjourned." Within hours, the courthouse was in turmoil. FBI agents arrived with warrants for Hoffman's office and home. Patterson was seen being escorted to an interview room. Judges huddled in small groups, speaking in hushed tones about the implications. The district's chief judge called an emergency meeting of all judges for the following morning. Montgomery returned to his chambers to find Zoe, Marcus, and Professor Wright waiting, having been updated by Judge Fleming. Hoffman and Patterson weren't just trying to protect themselves from bias allegations, Wright said without preamble. Those cases they accessed, we've begun reviewing them, and they show a pattern of serious constitutional violations. Defendants who never received exculpatory evidence, coerced pleas, fabricated probable cause. How many cases? Montgomery asked. Dozens confirmed so far, Marcus replied. Potentially hundreds more. Almost all involving defendants who couldn't afford private counsel. Zoe's expression was a mixture of vindication and dismay. This goes beyond bias, beyond even individual misconduct. This is systematic subversion of due process. Montgomery nodded, understanding the full dimensions of what they'd uncovered. A two-tiered system of justice, one for those with resources and connections, another for everyone else, with judges like Hoffman and Patterson ensuring the machinery kept running smoothly. And you nearly became their scapegoat, Wright observed. No, Montgomery corrected. I was their colleague and enabler for years, even if I never actively participated in their worst abuses. My biased sentencing was part of the same system, the same culture of impunity. The next morning, Montgomery entered the judge's conference room, aware of the eyes following him, some hostile, others uncertain, a few openly supportive. Chief Judge Harriet Chen took the podium, her expression grave. Colleagues, we face a crisis unlike any in the history of this district. The allegations against Judges Hoffman and Patterson are devastating not just to them, but to public confidence in our entire judiciary. Judge Montgomery's evidence appears conclusive, and the FBI investigation is expanding hourly. She surveyed the room. Beyond the criminal investigation, we must address the broader issues raised by the Justice Project's work and the Judicial Practices Review Panel. The data on sentencing disparities cannot be dismissed. The evidence of systemic failures cannot be ignored. A judge near the back called out, "What exactly are you proposing, Harriet?" "A complete overhaul of our practices and procedures," Chen replied firmly. "Independent review of past cases, comprehensive bias training, community oversight, sentencing guidelines reform, all the measures that Judge Montgomery and the panel have been advocating." She fixed the room with a steely gaze. "We can lead this transformation ourselves, or we can have it forced upon us by federal oversight, but change is coming either way." The room erupted in debate, with Montgomery finding himself in the unfamiliar position of defending reforms alongside judges like Fleming, while former allies looked on in confusion or contempt. As the meeting continued, Montgomery stepped out briefly for water and found Zoe waiting in the hallway. "I thought you might want to know," she said. "The first 50 case reviews are complete. 38 defendants have been released already based on due process violations. Marcus is working with them on re-entry support." Montgomery felt the weight of those numbers. Lives derailed, years lost, families separated. "It's a start," he said quietly. "Yes," Zoe agreed. "A start." She studied him thoughtfully. "What happens now? For you personally, I mean." Montgomery considered the question. The past month had dismantled nearly everything he'd believed about himself as a judge and about the system he'd served. Yet strangely, he felt more purpose now than he had in years. "The panel's work continues," he said. "The case reviews, the reform recommendations, the hard conversations with colleagues who still don't see the problem, and eventually, I hope, a judiciary that better reflects the principle carved above the Supreme Court: equal justice under law." "You know," Zoe said with the hint of a smile, "when I stood in your courtroom that first day, I never imagined we'd end up as allies." "Neither did I," Montgomery admitted. "But then, I never imagined a lot of things that turned out to be true." He extended his hand. "Thank you, Ms. Taylor, for helping me see more clearly." She shook his hand firmly. "The work is just beginning, Judge Montgomery." "Indeed it is," he agreed, turning back toward the conference room where his colleagues continued debating the future of a system in desperate need of transformation. Indeed it is,